Bob, this case is in New Jersey. Your case was in New Jersey as well. What are your thoughts tonight on where we are in prosecuting women going after little boys or little girls?
There's a double standard. It's existed, and it still exists. And what's shocking to me, listening to the two ladies on the program, who I greatly respect, is that we've all had such similar cases. Mine was a civil case as well. And I could not get the prosecutors. It was the same exact scenario. The teacher somehow ingratiated herself with the family, wound up having the kid live in her home where she sexually assaulted him for a number of years. And the prosecutor literally said to me, a female prosecutor, may I add, a female aggressive sex crime prosecutor said, oh, come on, it's every schoolboy's dream. Literally couldn't get her to prosecute the case. And civilly, it was the same thing. Where are your damages? Come on, attaboy, that kind of stuff. And you know what, Vinny, what I learned from the psychologists that were treating my client at the time, it's the inability to give a line so that the male victim of sexual assault realizes that what's happened to them is a crime that they can't begin to heal. And there's even a greater level of addiction, sexual abuse history down the road, and suicide, because these boys are turned into people patting them on the back on one side, and then other groups of people saying they're victims. And lastly, just to the point of whether or not we have gone to the double standard, I'm in court all the time. I'll wait for the next segment because I think you're going to go there. But I asked the question, if you had a grown man who was a teacher and the student was in the custody and care of that teacher, and that student was a female, and that student was sexually assaulted by a predator 416 times, which makes that person a serial predator, would there ever be a chance that they would not stay in jail and be detained until they had their trial? Can we envision look, we handle cases, Vinny, where you get involved in a much lower level of a sexual assault crime and you're a guy and you don't get out. I guess we'll wait to see the FYIs with the judge here. Maybe that'll answer the question if there's a double standard. So, Vinny, I'm really proud of New Jersey's bail reform because unlike the disasters that have happened in other places, it takes into serious consideration the nature of the offense and the level of damage and the amount of time a person can do. Now, in this particular instance, the prosecutor kind of shorted it a little bit. It's not just 20 years on the aggravated sexual assault. It's also because of her relationship as a teacher is a whole nother charge that can be consecutively sentenced. And when they get around to the indictment before the grand jury, I'm pretty confident as a prosecutor they're going to throw a little official misconduct in there as well to sprinkle another consecutive sentence. So given all of those things together, I will say, to be fair, she came out on the low end of the PSA score, a 1-1, which is the lowest. However, the probation department that does that public safety assessment said she should still be detained because of the nature of the offense and the danger to the community, and that's what the prosecutor also argued. Last point. I think this prosecution made one slight mistake here. When the defense made an argument that wasn't shown on that clip, but they did, that this same judge with this same lawyer on another case with a person charged with a first-degree aggravated sexual assault, a male in that case, the judge had the courage or some word to that effect to release him. The prosecutors should have stood up at that point. Instead, they didn't and said, wait a minute, this is a person who was in a position of trust. This is actually a kidnapping of this child. This is a person who actually worked the will, mind, and intent of this kid to sexually abuse him 416 times. And like my client said many years ago, confused this young child at 11 as to whether or not she was acting as his teacher, working as his mother, working as his girlfriend, or the father of her child, and nobody should have to go through that. In my opinion, I asked all my staff, does anybody think that this defendant is going to get out on the detention motion? Everyone said, no way. And then I said, the person did get out. They were a female. The response back by my crew was, okay, that figures.
That figures. Stacey, I want you to take a listen to something else that the defense attorney talked about here, which was the arrest of his client before there was any DNA evidence. Let's take a listen.
The state did something in this case. They made a conscious decision to make an arrest before there was any DNA investigative work done in this case. So now after Laura has been arrested, and only after the arrest, They get search warrants for her DNA. They got the victim's DNA voluntarily from him, and they have a search warrant for my client's 5-year-old daughter for her DNA, and that will take months for that evidence to be that biological evidence to be obtained, sent to the lab, and processed. And Judge, we think that the DNA evidence is really going to tell the tale in this case. But what's missing from the state's case right now, notwithstanding the state's argument to the judge, to the court, there is no DNA, no medical evidence, no physical evidence, no microscopic evidence, no fibers, no nothing to back up the allegations made.
Okay, Stacey, let's talk about the DNA. If they test that child, and that child ends up being the child of the then 13-year-old, may have been 12 at the time, he was 13 when the child was born, it's game over, right?
Yeah, but, you know, Vinny, you have to remember something else, and everybody on this panel knows this. You know, sometimes DNA comes afterwards. What about all the other evidence prior to this? You've got the admission from the victim himself that he was sexually assaulted all of these times. It didn't take 416 times for her to get pregnant. So even if you didn't have DNA in a case, but you have a victim who says that he was sexually assaulted, you have him living at the house, you have the sister seeing him come out of the room, not sleeping in his bed, coming out of the shower. You've got all of these other factors that the court takes into, that the prosecutor takes into consideration. The DNA, of course, is the cherry on the top. Of course, that is game over. But you've got sexual assault charges, even without knowing at this juncture if that baby belongs to him.
And Ann Bremner, all that evidence, that's what we call direct evidence. If you have an eyewitness who sees it happening, if you have the victim saying what happened, that's the kind that the defense attorneys always say, this is a circumstantial case. Now they're complaining because there is no circumstantial evidence. There's just the direct evidence.
Well, exactly. You're exactly right, and Stacey is too. And the thing, just circumstantial evidence. I always love that. We all know that direct evidence is as valid as circumstantial. I like circumstantial better. I mean, witnesses can be mistaken, they can lie, but evidence never lies. I mean, Mary Kay Letourneau's case had no DNA. I mean, he said, you know, we slept together. I mean, you don't have to. I mean, it's like, it doesn't take a rocket scientist to make this case, to connect the dots that she was sleeping with him. And whether it's their baby or not, I don't care. I don't think the jury's not going to care. And so he's basically arguing on release, well, we don't know yet if she's really the one. That's kind of what he's saying. You know, but the fact is, Mary Kay Letourneau, when she was released initially, she'd been in jail, got probation.
She couldn't help herself. She couldn't stay away. No, she couldn't stay away.
She ended up in a steamed-up car filled with Nordstrom bags and passports and cash, and she was pregnant.
Yep. Bob, let me ask you, what if that DNA comes back and he's not the father? What happens here?
Well, let me go. The first part is I laugh when I hear these stories. I tried all my murder cases when I was a baby prosecutor. We didn't have a scintilla of DNA. We didn't have cell phones, computers. I now wonder, like, how did we even get these convictions? But we did. So yeah, I agree with that. Listen, obviously, if that baby does not come back to his DNA, that is going to be a major credibility problem in the prosecution's case. I don't think that that's going to happen based on everything they said and everything that they have right now, because that would mean that they just made the whole thing up whole cloth. Has something like that happened? Well, we can go back to the Margaret Kelly Michaels case and talk about how people were interviewed and witnesses were manipulated and an innocent person was charged with a crime. I guess it's possible, Vinny, but I'm not seeing it in this case. And by the way, last point, I don't like the argument, why didn't prosecutors get the DNA? Prosecutors got enough evidence, as your guest indicates, that this person is a sexual, repeat, by the way, sexual predator, and they are not going to sit there and wait for 4 months for a lab to come back with a DNA test. And by the way, they have to get the DNA from her, which means they got to get a warrant, which means she would then know about the investigation. And so we would have a person that knows about the investigation out there potentially victimizing other children.
Yeah, it would be nice for the jury to get the full picture of what's going on here. Bob Bianchi, and I just think about Danique, the way she was abused and mentally tortured to abandon her family, be taken away from her family. Then she just gives birth and has a little baby at home, and then this happens.
Hey, Vinny, I can't really see this much different than the teacher who winds up taking this child and gaining trust and takes him away from his own parents and rapes him at 11 years old to older. But yes, listen, I'm really interested in this case in particular with what we call the 404 or other act evidence and to what extent the judge is going to allow that in. Because typically speaking, all these things that are ancillary to the actual murder itself or kind of outside are not admissible unless they go to prove motive, intent, opportunity plan, absence of mistake, or rebut a claim or defense. Here it's going to go towards motive. And it'll be the prosecutors need to be a little bit careful here because this is like an instruction I say to people all the time at being a trial training prosecutor. The judge may give you more latitude than the Supreme Court is comfortable with. So be precise, use it, but don't use it too much in order to establish that motive. So I'm really looking forward to seeing what will the court do with regard to the admissibility of the evidence, because you always win or lose on the evidence. And a good prosecutor prepares for that from the day they pick up the file.
And Stacey, a jury's going to want to know why, right? And if the only explanation they have is that he made a mistake, he thought it was someone that was coming after him, and he just got confused, he didn't think it was his so-called wife, at a minimum, they should know that his wife is also his stepdaughter, right?